You've just got a notice, maybe. Or maybe you're just trying to get ahead of things, wondering what your rates actually are as a renter here in Southern California heading into 2025.
Yeah.
That's exactly what we're digging into today. We're looking at the changing rules for tenant rights and, really importantly, the protections you have against eviction this year.
Mm-hmm.
Think of this as like your quick guide to feeling secure where you live.
And it's a really, really critical time to understand these protections.
Yeah.
Especially if you're renting down here, Orange County, Riverside, San Diego, maybe LA.
Right.
Knowing your rights, it's your first line of defense, really, for keeping stable housing.
Exactly. So our mission today is pretty straightforward. Cut through all the legal jargon and give you the essentials. What you need to know about your rights as a tenant and those eviction protections for 2025.
Yeah, give you actionable knowledge.
Right. Clear, actionable knowledge without, making your head spin. We're focusing on what's new, what's solid when it comes to your security as a renter.
And we'll be looking closely at the legal framework, the actual laws that give you these rights, based on, well, the latest updates in California.
Okay, let's dive right in then. What's the biggest change, you think, in the legal landscape for renters, specifically in Southern California for 2025?
Well, the trend is clear. California's been strengthening renters' rights. Recent changes, particularly those kicking in around 2025, they've made it tougher for landlords to, let's say, push through evictions that might not be entirely fair.
So stronger protections.
Definitely. The whole idea is to make things, a bit more balanced, clearer rules for everybody involved.
So it's not just like the same old situation we've been dealing with.
Not really, no. The 2025 framework definitely offers better safeguards if you're facing eviction. But here's the thing.
Yeah.
To really make these protections work for you, you absolutely have to keep good records and respond quickly if any legal papers show up.
Documentation and speed. Got it. Okay. We hear this term a lot. Just cause eviction. Can you break that down? What does just cause mean for a renter in simple terms?
Yeah, just cause is basically the bedrock of your protection against being kicked out arbitrarily, especially if you've been living in your place for, say, 12 months or more.
All right.
It just means your landlord needs a legitimate, legally valid reason to end your tenancy. They can't just decide they don't like you anymore.
And these reasons, they fall into categories.
Right. Generally, two types. Reasons that are considered your fault, at fault, and reasons that aren't your fault, no fault.
Okay, let's start with the at fault ones. What are the usual legal reasons a landlord might use there?
Well, the common ones are still valid. Things like, obviously, not paying rent, breaking a major part of your lease agreement. Maybe you got a dog, but the lease says no pets.
Right.
Creating a nuisance, like disturbing neighbors constantly. Using the place for something illegal, criminal activity happening there, or directed at the landlord. Also, refusing to let the landlord enter when they have a legal right to, or refusing to sign a new lease if it's basically the same as your old one.
And rent non-payment,
Right.
Still a primary reason.
Oh, yes. Non-payment is still a very valid reason. But it's worth noting some newer rules might give tenants a bit more breathing room, maybe more time to pay up, depending on the situation. Always check the specifics.
Okay, and what about those no-fault reasons? Those sound like they could just pop up unexpectedly.
They could feel that way, yeah. No fault means the eviction isn't because of something you did wrong. The classic one is the owner wanting to move in themselves or, move in a close family member.
The owner move in.
Exactly. But SB 560, a key law, has really put stricter rules on that. Now, generally, they have to actually move in within 90 days and stay living there for at least a full year.
Wow, okay, that's specific.
Very. Other no-fault reasons include the owner planning to demolish the building or do a substantial remodel. And I mean substantial. SB 560 as it makes it clear, cosmetic stuff like new paint or carpet doesn't count.
So they need proof.
Yes, they usually need permits pulled or signed contracts to show it's a major job. Also, a landlord might take the property off the rental market completely, or maybe they need to comply with a government order regarding the unit.
And what if they fudge the reason?
Well, that's a crucial point. Lying about the reason for a no-fault eviction, that's illegal.
So definitely stricter rules now, especially for owner move-ins and those big remodels.
Absolutely. Especially with SB 567 fully effective after April 1st, 2025. There's much more accountability. Landlords need genuine intent.
And if they say remodel but don't do it?
That's interesting. If they evict you for a substantial remodel and then, don't actually start it or finish it properly, you might actually have the right to move back in under your old lease terms.
Good to know. Okay, now, what happens if a renter feels like they are being pushed out unfairly? What exactly counts as a wrongful eviction, and what can they actually do?
Right, so a wrongful eviction is basically any attempt by the landlord to force you out illegally, like changing the locks while you're out,
Oh, wow.
or shutting off your utilities, water, power. Those are huge red flags. The absolute key thing to remember is this. In California, a landlord cannot legally remove you without a court order, period.
They need to go through the courts.
They absolutely have to go through the proper legal eviction process, which ends with the judge's order. No self-help evictions allowed.
And if a landlord ignores that and tries, say, the lockout?
If you're facing that kind of illegal eviction, you have some pretty strong legal tools. The laws now provide for significant compensation.
Like what kind of compensation?
We're talking economic damages, things like your moving costs, finding temporary housing, maybe even lost wages if the illegal eviction messed up your job.
Okay.
And on top of that, non-economic damages. That's for the emotional distress, the disruption to your life and community from being unlawfully forced out.
So you can sue them.
Absolutely. If you're displaced without that proper court order, you have the right to sue your landlord for damages.
Okay, let's shift gears slightly. Say the landlord does go through the courts. A renter gets served with that formal eviction lawsuit. I think it's called an unlawful detainer.
That's right, unlawful detainer action.
What's the number one thing they need to know when they get those papers?
Time. The clock starts ticking immediately, and it ticks fast. You have a very, very limited window to file a legal response with the court.
Okay, how limited are we talking?
If someone hands you the papers directly, that's personal service. You typically have only 10 calendar days to file your response.
10 days.
Yep. And weekends and court holidays don't count towards that deadline, which is important. If they use another method, like leaving it with someone and mailing a copy or posting and mailing, you usually get a bit longer, often 20 days from the mailing date.
And if you miss that deadline,
That's the danger zone. If you don't file your response on time, the landlord can ask the court for a default judgment. That means you could be evicted without ever getting a chance to tell your side of the story in court.
so that response is absolutely crucial. What does it actually do?
That response, usually it's a form called the answer, is your formal way of telling the court why you believe you shouldn't be evicted. You get to respond to each claim the landlord made in their lawsuit.
And what kind of defenses could a renter raise in that answer?
There are quite a few possibilities. You might have procedural defenses. Maybe the landlord didn't give you the correct type of notice before filing or didn't serve the lawsuit papers correctly.
Okay.
You could raise habitability issues, arguing the landlord failed to maintain the property in a livable condition, which might affect your rent obligation. Rent control violations could be another defense, if applicable.
What about the reason itself?
Yes, substantive defenses. You could argue the eviction is retaliatory. Maybe they're trying to evict you because you asked for necessary repairs.
Retaliation.
Or that it's discriminatory, based on race, family status, source of income, etc. Sometimes, instead of an answer, you might file something else first, like a motion to quash service if you think the service was improper, or a demurrer if you think the lawsuit itself is legally flawed.
Sounds complicated.
It can be. That's why getting legal advice is often so important. But the point is, filing a strategic, timely response can make a huge difference in the outcome.
Okay, moving beyond just the eviction process itself, what about basic living conditions? What fundamental rights do renters have there in 2025?
This is core stuff. You have a right to a habitable or livable home. It's legally called the implied warranty of habitability.
Warranty of habitability. Okay.
It means your landlord has a legal duty to maintain the property in a safe, sanitary condition. Essentials need to work: plumbing, heating, electrical.
What else falls under that?
Things like effective waterproofing, weather protection. The place needs to be free from major pest infestations, rodents, cockroaches, proper trash disposal, working smoke detectors, carbon monoxide detectors, basic health and safety standards.
And if things aren't up to par, if the heat breaks or there's a leak?
Your first step is always to notify your landlord. Do it in writing, email, or certified letter so you have proof. Give them a reasonable amount of time to make the repair.
And if they drag their feet or ignore it?
If they don't act, you have options. You can contact your local city or county code enforcement or health department. They can inspect and order the landlord to make repairs.
Does that connect back to eviction?
It absolutely can. If you're facing eviction, especially for non-payment of rent, and there are serious habitability problems the landlord hasn't fixed after being notified, That can be a powerful defense in your unlawful detainer case.
What about that retaliation point you mentioned? If a renter does complain about repairs or maybe an illegal rent hike, are they protected if the landlord gets angry?
Yes, very much so. California law specifically prohibits landlords from retaliating against tenants for exercising their legal rights.
So they can't punish you for speaking up.
Exactly. They can't legally take negative action against you because you asked for necessary repairs, or reported code violations, or joined a tenants union, or asserted any other right you have under the law.
What would count as retaliation, legally speaking?
It could be things like suddenly hitting you with a rent increase right after you complained, or taking away services like access to laundry facilities, or, most seriously, starting an eviction process shortly after you exercised a right. There's often a presumption of retaliation if these things happen within a certain time frame, like 180 days.
And if you think you are facing retaliation,
You can file complaints with relevant housing agencies. You can also raise retaliation as a defense in an eviction lawsuit. And you might even be able to sue the landlord for damages caused by the retaliation.
okay, good to know. Let's quickly hit a few other key rights. What about rent increases and security deposits? Any changes there for 2025?
The basics are still crucial. For rent hikes, landlords need to give proper written notice. 30 days for increases of 10% or less, and a longer 90 days notice if the increase is more than 10%.
And there's still that statewide cap.
Yes, the Tenant Protection Act, AB 1482, has a statewide rent cap. Through July 31st, 2025, it limits annual increases to the lower of either 10% total or 5% plus the local rate of inflation, CPI. Remember, though, some cities have stricter local rent control rules.
Right, local rules can be tougher. And security deposits.
Landlords have 21 calendar days after you move out to return your security deposit. If they deduct anything for unpaid rent, damage beyond normal wear and tear, necessary cleaning, they must provide an itemized statement explaining those deductions, along with receipts if applicable.
21 days, got it. Any other key protections, maybe discrimination or foreclosure?
Definitely. Discrimination is illegal. Landlords can't refuse to rent to you or treat you differently based on protected characteristics like race, religion, gender identity, disability, source of income, like using a Section 8 voucher, and many others. They also can't threaten you based on your immigration status.
And if the property goes into foreclosure?
If you're a tenant in a property being foreclosed on, the new owner generally has to honor your existing lease. If you're month to month, they usually have to give you at least 90 days notice to move out. They absolutely cannot just change the locks. Some cities offer even more protection against eviction due solely to foreclosure.
Okay, this is a lot of great info. Pulling it all together, what are the absolute most important steps a renter in, say, Orange County or LA should take right now to protect themselves?
Number one, without a doubt, document everything. Keep copies of your lease, rent payment receipts, or bank statements, all written communication with your landlord, emails, letters. Take photos or videos of the property condition when you move in and if issues arise. Records are your best friend.
Okay, document. What else?
Second, act fast. If you get any notice from your landlord, especially something that looks like an eviction notice or court papers, don't ignore it. Don't delay. Those deadlines, like we talked about, are incredibly short.
Right, the clock is ticking.
Exactly. And third, given how complex these laws can be, seriously consider getting legal advice, especially if you're facing an eviction lawsuit. Look for lawyers or organizations that specialize in tenant rights.
Where can people find help?
lawhelpca.org is a great starting point to find free or low-cost legal aid services in California. And for tenants specifically in Southern California, Orange County, Riverside, San Diego, Los Angeles, needing experienced help with eviction, defense, or other tenant issues, our firm, Martinez Law Center, focuses exclusively on representing tenants. You can find us at martinezlawcenter.com.
martinezlawcenter.com. Good to know. And finally,
Just, stay informed, know your rights under state law, and also any local ordinances, which can offer even stronger protections in some cities. Knowledge is power here.
so wrapping up for renters in Southern California in 2025, the main takeaway is
California law gives you significant protections, probably more than ever before. But these rights aren't automatic. You need to understand them and be ready to assert them to truly secure your housing.
and your final piece of advice for our listeners.
Keep those meticulous records we talked about. Respond promptly if you get any legal notices. And please, don't hesitate to seek qualified legal help if you're in a tough spot with your landlord or facing eviction. Again, for tenant-focused representation in Orange County, Riverside, San Diego, or LA, check out martinezlawcenter.com.
Excellent. And maybe a final thought for everyone listening. We know these protections are stronger now, but how can you, as a renter, be even more proactive day to day to make sure you feel secure in your home in this really dynamic rental market? Something to think about.
Call now 714-442-9741. Thank you.